evening. We'll get started, and before I begin with opening remarks, I would like to thank our host, Ed Getz from Drinker, Biddle, and Wreath, who kindly provided our forum for this meeting. My name is Candace Klein, and I'm with the law firm of Carpenter, Lips, and Leland. I am a partner in our Chicago office, and I also am proud to serve as a co-chair of our Chicago lawyer chapter here in Chicago. We are very pleased to offer this talk with Professor Aziz Huq to talk about the travel ban. Briefly, in terms of his history with this issue, it goes back some time and it will continue. Professor Aziz Huq is the Frank and Bernice J. Greenberg Professor of Law at the University of Chicago Law School. He has done significant work with regard to constitutional design and individual rights and liberties, and that includes work both here in the U.S. On issues such as the travel ban, but also internationally, looking at constitutional law and policy in other jurisdictions, for example, Pakistan and Afghanistan. The research and scholarship on the travel ban, I'm sure many of you are familiar with this, it's obviously a continuous and evolving landscape. It has ricocheted through the courts. It will be obviously introduced in the Supreme Court, and Professor Huq can talk more about that as well. I would encourage you to look at some of his writings on this issue. So, for example, there was an interesting article on the travel ban, executive orders as a separation of powers test case. There are other constitutional writings, books and articles and publications that may also interest you on both the evolution of the executive order, but also how it's been tested in the courts. So with that, let me introduce Professor Aziz Huq for your talk this evening. Thank you.
Thanks, Candace. And thank you very much, Ed, for kindly hosting this event. And thanks to all of you for spending your evening thinking about this issue. So as Candace said, I teach at the University of Chicago. I am also a cooperating attorney with the ACLU of Illinois and with an organization called Muslim Advocates that's a national advocacy organization that's based in Oakland in California. And in the latter capacity, I've been involved in the litigation concerning the travel ban on the plaintiff side since the first iteration of the ban in January of 2017. And you ought to know that just by way of understanding the perspective that I'm coming from. I'm no longer a lawyer on any of the travel ban cases, but our Supreme Court clinic at the law school is filing an amicus brief in the case, a federal court scholars brief, and I've been helping with that brief. So I remain involved, although in a different capacity. And again, that's an important disclosure to make before I talk about the case. What I thought I would do is to walk through relatively briskly the history of the policy that is at stake in the challenge to the travel ban, Hawaii versus Trump, that will be argued before the Supreme Court in April and probably decided by June. What I thought I would spend the bulk of my time doing is talking about the statutory and the constitutional law issues that I think will make up the meat of the court's consideration when the case eventually is heard. It's necessary to give some background just to explain what those statutory and constitutional law questions are, however. So let me start with background and then jump into kind of the more technical legal issues. So there have been 3 iterations of the travel ban in January of 2017, March of that same year, and then in September of 2017. Each of the travel bans has prohibited the entry into the United States of a different class of persons. the classes of persons covered by the ban have varied from the first to the third ban. But in each case, the scope of the prohibition has been defined in terms of the nationality of the person entering. And in the third travel ban's case, the kind of visa that they were entering on. Notwithstanding this continuity, there has been considerable change in the scope of the travel ban over time. So to give you some sense of that, it's worth pointing out, or by way of contrast, that the first travel ban, the one that was implemented in January 2017, was initially promulgated and interpreted to apply to all nationals of 7 countries, regardless of whether they possessed lawful permanent resident status in the United States. The consequence of that, way of drawing the scope of the prohibition, was that the first ban as implemented led to the exclusion, at least temporarily, of lawful permanent residents, or colloquially green card holders, from the enumerated countries from the moment that the ban was implemented late on a Friday afternoon. It was as a consequence of that very broad scope that the initial travel ban generated the degree of chaos and confusion that it did. Right? The order as it was initially implemented literally made it unlawful for residents of the United States returning from holidays from business, arriving at U.S. airports. It made it illegal for them to enter and return to their homes. So, for example, when I was volunteering at O'Hare, on the Saturday after the travel ban was promulgated, I was working on behalf of an Iranian couple in their 70s who were both green card holders, who were returning from a wedding overseas, not in Iran, in fact, but in Europe, but who suddenly found themselves dispossessed of a home. Over time, the scope of the travel ban has been, in many fashions, in many respects, pruned back, although in at least one respect it's been expanded. The third iteration of the travel ban was the result of judicial challenges to the first iteration, a set of judicial challenges that culminated in an opinion by the Ninth Circuit invalidating and enjoining that first iteration, in part because of its overbreadth and the absence of a relationship between the breadth of the prohibition and the reasons stated for the policy. That first enjoined ban was superseded by a second ban that was slightly narrower. That second ban was once again challenged. It was once again struck down not just by the Ninth Circuit, but also by the Fourth Circuit. After those two circuit court rulings in the summer of 2017, the Justice Department appealed the Fourth Circuit's ruling invalidating the ban to the Supreme Court. The court accepted the case, issued an order in June of 2017, narrowing the injunction that the Fourth Circuit had upheld, narrowing the injunction so it applied only to individuals covered by the ban who had what the court called a bona fide relationship to the United States, but otherwise placing the challenge to the second ban on the court's calendar for the beginning of the October term 2018. Prior to the court's consideration of the second travel ban, that travel ban, which had been slated to be in effect for 90 days, expired. Right? The first and the second ban were both time limited in their scope. They purported to be promulgated to enable a review process within the Department of Homeland Security and other related agencies, a review process that was supposed to occur within a roughly 3-month period. Rather than extending the second travel ban, the administration promulgated the third travel ban. The third travel ban, as I said, is both narrower and broader in scope than the first two bans. It's narrower in as much as it again covers a list of specific countries, although different countries from the first and the second iteration. So, for example, Iraq was on the first travel ban. It's no longer on the ban. Additional countries such as Chad, Venezuela, and North Korea are on the third ban. They were not on the first or the second ban. So there's a difference in scope in terms of the nationalities covered. Within those nationalities, the third travel ban, unlike the first and the second travel ban, specifies the class of arriving persons who are covered by the prohibition. So, for example, Iran, with respect to Iran, all immigrants from Iran, anyone arriving, for example, on a visa related to family reunification, is covered by the ban. All non-immigrants are also covered by the ban, except for students arriving on an F or a J visa. Right? So Iran, the ban carves out a class of students who are eligible to attend US colleges through the two main visa programs that exist for that purpose. In contrast, the prohibition on Syrians is blanket. Right? Syrians, whether they're arriving on a non-immigrant visa, which means they're arriving, for example, by dint of family-based immigration under the INA, or whether they're arriving under a student visa, a business visa, or a tourist visa, are per se prohibited. When it comes to nations such as Venezuela and North Korea, the third travel ban is even more tailored. So with respect to Venezuela, there are specific classes of persons who are covered by the prohibition. Right? Mostly people who are connected to the Venezuelan regime. So the third travel ban draws much finer grained lines, sorting between different categories of immigrants and non-immigrants as to particular nationalities of persons arriving at the border. It also enumerates a slightly different cluster of nationalities. Right? So in those ways, it's in important respects narrower, right? And most importantly, it does not cover green card holders. It does not cover people who already have a right to live in the United States. In another respect, however, it is broader, right? And this is a fact that is relevant to the litigation, right? It is broader in as much as it is permanent. Although the proclamation envisages a process of periodic review, right? The Secretary of Homeland Security, which is now Christian Nielsen, is supposed to, every 180 days, look at the enumerated list of countries and ascertain whether the bases for excluding nationalities from those countries, right? And the bases that are listed generally, but not always, have to do with the quality of screening and security protocols in the enumerated countries: Chad, Syria, Iran, Venezuela, North Korea, etc. There's supposed to be a process of review. It's entirely unclear whether such a process of review will happen, and if so, whether there'd be any change in the scope or the force of the travel ban. Right. So there's a permanency to this version of the travel ban that was not the case with respect to earlier bans. The president promulgated this third iteration of the travel ban, as I said, very different from the two earlier iterations, in September of 2017. The Supreme Court promptly vacated the Fourth Circuit and the Ninth Circuit rulings, invalidating the earlier iteration of the ban under a doctrine called the Munsonware Rule, and sent the litigation in both cases back to the district courts in Virginia and Hawaii. Not surprisingly, the entities challenging the ban, in one case Hawaii and the state of Hawaii and a number of citizens from the state of Hawaii, and in another case a refugee assistance organization called IRAP, renewed their challenge. They made basically the same cluster of challenges to the ban that they had made before. Those challenges prevailed in the District of Hawaii and in the Eastern District of Virginia, right? It was the prevailing challenge in Hawaii that prompted Attorney General Sessions' remark about judges sitting on islands in the Pacific, that you might recall. Both of those decisions were then appealed up to the respective circuit courts. This appellate process played out a little differently from the earlier appellate process. It was the Ninth Circuit that ruled first on the travel ban 3.0, and the Fourth Circuit that, sitting in Bonk, came in later. As a consequence, the case that has gone to the Supreme Court is the Ninth Circuit case, right? And this matters largely because the plaintiffs in the two cases are different. And as a consequence, the Article 3 standing analysis that's presented, or the Article 3 standing problem that's presented in the two cases is distinct and different. And I'm happy to talk about the differences between the Article 3 analysis and the two cases. So there's different plaintiffs in the two cases. There are also differences in the legal bases for the Fourth Circuit and the Ninth Circuit rulings. And I'll walk us through the legal issues, the core legal issues that are in the case next. The Ninth Circuit decided the case on largely statutory grounds. The Fourth Circuit decided the case, or at least in majority. The Fourth Circuit issued a very fragmented opinion. The Fourth Circuit decided the case on constitutional grounds. The way the case has gone up to the Supreme Court, the opinion that the justices will be reviewing is solely a statutory opinion, doesn't directly engage in constitutional analysis. Moreover, the lawyer for Hawaii, Neil Katyal, who was the acting Solicitor General, is committed, and I say this from having had conversations with him and his colleagues, to arguing the case as a statutory case and not as a constitutional case, right? The Fourth Circuit litigants, who are primarily represented by the ACLU, are much more focused upon the constitutional issues and want to make the case about a constitutional case, and have sought leave to intervene in the Supreme Court, and therefore to get argument time, in order to brief and orally argue the constitutional issues, and in particular the Establishment Clause issue. Right. So that's the posture of the case. And so as the case has gone up to the Supreme Court, much of the briefing is about, on the one hand, the technical issues of justiciability. Right. Are these the right plaintiffs, suing at the right time, using the right procedural vehicles? Right. That ends up being about half of the government's brief. It probably will be about half of Hawaii's brief. It's the subject of the amicus brief that our Supreme Court clinic is working on. And then I would say that of the remaining half, 80-90% of the remaining argument is focused upon statutory issues. And the constitutional issues that I think most people have focused upon when they look or think about the travel ban are really squeezed into this very narrow kind of almost afterthought in the Hawaii briefs, in the government brief. I'm sure there will be an ACLU brief making a full-throated constitutional argument, right? And I'll say, not to be disloyal to the ACLU, which I've worked with a great deal, but it's my view that that the approach taken by Hawaii is the one that is much more likely to yield a successful judgment from the perspective of the plaintiffs, and that the full-throated constitutional analysis is much more difficult. So that's the posture of the case, and that's the nature of the dispute as it's come before the Supreme Court. So what are the statutory and the constitutional law issues in the case? Right. So I'm happy again to talk about the justiciability issues. There's a really important set of questions about the ability of courts to hear challenges to immigration decisions under certain circumstances. The government has an argument about something it calls the consular non-reviewability doctrine. Right. This is this I think is a genuine and important doctrinal argument that I think is one that the court will spend some time addressing. But for the sake of time, at least, what I want to do is to focus instead upon the statutory and the main statutory and the main constitutional arguments that the court will, I think, have to grapple with if it gets past all the threshold justiciability questions. And I'll say a little bit about both and then open it up for questions, and hopefully we can have more of a conversation rather than me nattering away at you. So what's the statutory issue? So the president has issued all three proclamations that are labeled travel bans under a power that is delegated to him pursuant to a federal statute, 1182F of Title 8. Right, this is part of the INA, the Immigration and Nationalization Act, that was added to the statute initially in 1941. There were subsequent amendments in the 1950s. And 1182F, the key statutory provision at stake in the case, allows the president, right, delegates to the president the power to prohibit entry to, quote, any alien or class of aliens if he makes a finding that such entry would be detrimental to the interests of the United States. Any alien or class of aliens if he makes a finding that such entry would be detrimental to the interests of the United States, right? It's clear that all three iterations of the ban invoke that statutory authority, and it's clear that that statutory authority is not insubstantial. It was the basis, for example, of President Reagan's decision in the 1980s to prohibit the entry of many or all Cubans at the time that the Mariel boat lift was going on. It was the basis of President Carter's decision to impose restrictions upon members of the Iranian regime in the wake of the Iranian embassy hostage crisis. During World War II, it was employed by FDR a number of times to prohibit the entry of certain persons who were not covered by the Enemy Aliens Act and therefore separately barred. All right, so this is a statutory provision that has a history and that has been employed a number of times in the past. The government's argument is that the broad terms of the provision, the idea that it can be any alien or class of aliens that can be prohibited, vests in the president a virtually unreviewable scope of discretion, a virtually untrammeled domain in which the president personally can make a determination that X or Y policy is permitted. Right? So the core of the government's argument on the merits is that the language of the statute is extremely broad. Right? The government, I think, doesn't argue, but could argue that the president, as the recipient of delegated power, is entitled to a measure of what administrative law scholars know as Chevron deference. Right? Chevron, for those of you who practice in the regulatory space will know, is the doctrine that says that when an agency receives authority as a consequence of a delegation by Congress embodied in a statute, that agency has pretty wide discretion about the meaning of that statute, right? The reason that the government doesn't make a Chevron deference argument is that it doesn't want to imply that the president's actions are in any way, shape, or form covered by the Administrative Procedures Act, right? In part because if the president's actions or the Secretary of Homeland Security's actions pursuant to the proclamation were covered by the Administrative Procedure Act, it's very clear that the plaintiffs would have a right of action to sue, and the government doesn't want to concede that the plaintiffs have a right of action, right? So the fact that their justiciability arguments, that is, are driving their deference arguments, I think. I assume that to be the case. I assume them to be savvy and strategic lawyers, and I think that's what's going on there. The Solicitor General I mean, it's a wonderful office that they're full of really wonderful and very, very effective lawyers. I may disagree with them, but they're good lawyers. What's the statutory and what's the constitutional argument on the other side? Well, the statutory argument is that 1182F, this key statutory provision, is actually carefully circumscribed and has to be understood in light of a larger statutory scheme that would be unraveled if, as the government contends, 1183F is read as a blank check to exclude anyone the president wants to exclude. Right? So you can't read 1182F as a blank check, because doing so pulls apart the seams of the balance of the Immigration and Nationalization Act. Okay, that's the form of the argument. Now that sounds like a very loosey-goosey argument, but let me give you two precedent in which that argument was accepted, and accepted by conservative judges. The first of those two precedent is a case from 2000 called FDA v. Brown and Williamson. FDA v. Brown and Williamson is a case that emerges from the FDA's decision under the Clinton administration to allow the FDA to find that it had jurisdiction over tobacco. Right? The FDA's jurisdiction is defined as covering any substance that's ingested or imbibed that alters or harms the body or the physiological processes of the body. Right? So the mandate of the FDA is described in extraordinarily broad terms, which plainly encompass tobacco. Right? Tobacco is plainly a drug, as that term is used in the FDA. So if you just look at the statute, right, it looks obvious that tobacco is something that the FDA can regulate. Now, of course, Brown and Williamson, Altria said, no, wait, hold on. This provision, the provision that grants authority to the FDA, is just one part in a much larger statutory framework. And if we look beyond the single element of the FDA's organic statute, the Food, Drug, and Cosmetics Act of 1934, and we look at the series of other statutes that Congress has enacted, for example, requiring certain kinds of labeling for cigarette packaging, banning advertising for cigarettes in certain locations, requiring certain protections for youth, for locations where the young are, and preventing advertising with respect to smoking there. Right? If we look at the entire statutory scheme, it is plain that this authorizing provision cannot be read to encompass tobacco, because that would sweep away, it would negate the effect of all of these other things that Congress has done. 5 justices of the Supreme Court, with Justice O'Connor writing, accept that argument. Right? Brown and Williamson invalidates the FDA order regulating tobacco. Second example, a much more recent one. This is a 2013 case called King v. Burwell. King v. Burwell is a case about the Affordable Care Act. It's the one that nobody knows about. You probably know about it. King v. Burwell is a case about whether exchanges created, healthcare exchanges created by the federal government are forums through which one can purchase insurance and obtain a subsidy from the federal government. Right? Without those subsidies, the insurance becomes unaffordable, and the market through the federally created exchanges unravels. So that what was at stake in King v. Burwell was what happens in every state which has not created an Affordable Care Act mandate. The text of the statute, again, seemed very clear, right? If you have an exchange created by the state, you can get a subsidy for insurance that's sold on that exchange. Exchange created by the state. An exchange created by the federal government is not an exchange created by the state. In an opinion by Chief Justice Roberts, however, the court stresses that language in a statute cannot be read in isolation. It has to be understood in light of a larger statutory framework. And there is an elaborate, let's just call it elaborate to be nice, an elaborate argument that Chief Justice Roberts makes to explain why exchange created by a state means exchange created by a state, except when it's created by the federal government, in which case we'll treat it like an exchange created by the state. How does that kind of argument work in the travel ban case? There's a couple of prongs to the argument. And I think that the most articulate development of these of the different prongs is actually the Ninth Circuit's per curiam opinion. I think it's a really well done opinion. The first observation, I think, in explaining why the third travel ban doesn't fall within the scope of the president's powers, is noticing that the statutory prohibition talks about suspensions for defined periods of entry. A suspension for a defined period is not a suspension or a termination of all entry for a class of persons indefinitely. Right? There's a difference between a time-limited suspension and a termination of entry privilege for a class of persons. Right? So even looking at the face of the statute, what the third travel ban does might be thought to be inconsistent with the power that's delegated to the president. Right? I'm not sure that on itself is a winning argument. I think that there's too much. It's too difficult to draw a line between suspensions and terminations or cancellations of permission to enter for the court to really rest very much on that claim. Rather, I think that the better argument focuses upon the other elements of the Immigration and Nationalization Act that are rendered superfluous by the president's interpretation of 1182F, much in the way that federal regulation of tobacco was largely rendered superfluous by the FDA's decision to regulate tobacco. So the Ninth Circuit points to two set clusters of provisions in particular, and then it tells a story about legislative history. The two provisions are first, the INA sets out a detailed framework for when and how people thought to be involved in terrorism should be excluded. Right? So with respect to the national security risk that is purportedly at stake in the travel ban, there's another section of the statute that deals with it and provides a precise definition of who can be excluded. The second important statutory interaction is a provision of the INA that was added in the late 1960s after the 1965 Immigration Act was passed, right? The 1965 Hart-Celler Act is important in immigration law because it abolished the country-based quotas that had existed in the immigration statute since 1924, right? Those country-based quotas had been calculated on the basis of the 1900 census with the express intent of weighting immigration to the United States toward Northern Europeans. Right? Northern Europeans were given preferential treatment by the 1924 Act's national origins quota system. Southern Europeans got the short end of the stick. There's legislative history about how undesirable people from Italy and Spain were. They didn't work hard and stuff like this is in the legislative history. People from Asia and people from so South Asia and people from East Asia were explicitly prohibited from emigrating, right, under the statute. Latin America and Africa don't even get a look in. They're just not even worth talking about in the statute, right? Congress, after it abolishes the national origins quota system, enacts a provision in the immigration law prohibiting all nationality-based discrimination. And even with the fine lines that the Travel Ban 3.0 draws, it is on its face a form of nationality-based discrimination. It applies invariantly to all all members of a nationality who don't fall within the vanishingly small class of persons who are eligible for something other than a non-immigrant visa or an immigrant visa. Right? So by and large, these are in function and effect nationality-based prohibitions. So this later enacted provision in the INA, which prohibits nationality-based discrimination, is basically rendered a nullity by the president's interpretation of 1182F. Right? I think that is the strongest argument that the plaintiffs have with respect to their statutory claim. I think it's this interaction between a 1941 statute and a 1968 provision which prohibits nationality-based discrimination. One more point that I think that will receive some attention. The legislative history of 1182F reflects the idea that it is a narrow prohibition designed to authorize an emergency, an exigent use of immigration discretion with respect to classes of persons who, particularly during wartime, right, come to the administration's attention and for whom there are very strong reasons to prohibit, but no statutory prohibitions. That was how the ban was initially articulated. That was how, and it was indeed limited to wartime under the initial 1941 iteration. That was how it was initially described. That was how it was initially used. And you can argue that's how it was used all the way through up to the Carter regime, right? Even after it was even after the wartime usage requirement was taken out, even when it was extended to non-war circumstances, an extension that makes a lot of sense if you think about the Cold War context, right? It remained a relatively targeted authority in its practical understanding and its legislative history, right up through the Reagan-era use of the prohibition with respect to Cubans and the Mariel boat lift. Right? So for the first 45 years of the provision's history, it has an understanding that fits securely alongside the other provisions in the INA, and that doesn't destabilize the statutory scheme as a whole. So I think that's going to be the set of statutory issues that the court's really going to focus on. There's also a constitutional issue. The constitutional issue is one that arises under the Establishment Clause. The claim under the Establishment Clause is that the the ban, when read in light of the statements made by President and candidate Trump, evinces a clear preference for one faith over another faith. And if there is anything that the Establishment Clause prohibits, it is government action that says this faith is the right faith and that faith is the wrong faith, right? That's a fairly straightforward proposition. It's a relatively easy case if you think you can account in adjudication for all the statements made by the president and by candidate Trump, right? And therefore, the meat of argument over the Establishment Clause, there is an argument that the Establishment Clause doesn't apply to immigration, which I don't quite understand how that gets off the ground apart from sheer, I can say the words, therefore it must be a cogent argument. I think that the main argument on the Establishment Clause side will be about it, to the extent the court reaches it, which I actually doubt, will be about, well, what kind of evidence counts? Okay, so I hope what I've tried to do is to give you a sense kind of the trajectory of the case and then of the set of issues that I think the court is really going to be most deeply engaged with. And I apologize if they are just not as sexy as you first thought they were going to be. That is the nature of Supreme Court litigation. The issues just become more and more boring as the case rises through the judicial. Unless you're representing, the Christian baker or the gay married couple, you're out of luck in terms of interesting arguments. With that, I'm delighted to talk or answer questions or have a conversation or whatever people think is appropriate.
Okay, so I have a question, and I practice in bankruptcy law, so we always get the statutory interpretation cases out of the Supreme Court. My query is on use of statements as a politician, right? So, he's not president. Anybody can say anything, right? So why would that now be held as a liability after the election and then once he assumes the official?
Right. So there's an issue in the case, and there's been an issue in the lower court litigation about whether and how the statements of either candidate or President Trump with respect to the ban can be employed as evidence of improper motivation. And there are two arguments with respect to inauguration statements that the government and lower courts or judges, particularly Judge Niemeyer in the Fourth Circuit, have made. The first argument is it focuses upon the fact that upon inauguration, the president takes the oath of office, right? So the idea is that as soon as you take the oath of office, the free play and willy-nilly verbal back and forth of campaigning suddenly ends, and you are immediately vested with this seriousness of purpose and commitment to taking care that the laws be faithfully executed, right? And even if you think that that's not the case with respect to any particular president, as a matter of law, the court has to presume that. The court has to presume that there is an acoustic separation between the behavior of a person as a candidate versus the behavior of the person in office. That's the first argument. The second argument is that there's a chilling effect, right? The argument is that if a candidate's speech can be employed as evidence of improper motive, this will prevent candidates from being fully candid with the public. That is the second argument. I don't find either argument particularly compelling. The argument about the effect of the oath, I think, is it's not obvious that the fact of taking an oath alters or ever would have been thought to alter the kind of states of mind, right, beliefs about the world that are captured by the term animus, right? Animus, as it's understood under the 14th Amendment, is a doctrine that goes to flawed states of belief about the world. Why would we think those change, right? Why would you think that the belief, let's say hypothetically, the belief that a person has, the person of racial group X are per se inferior, right? Why would that change when someone takes the oath? Right? There's no connection between the oath and that kind of belief. I don't see why we should think that therefore there is any legal effect of the oath on that set of beliefs. Moreover, really, do you think that presidents don't campaign for office when they're in office? Do you think that there's some kind of sharp separation between the campaign and the act of being president? That belies what we know about the behavior of modern politicians. On the second argument, the chilling effect argument, and this argument is made, former Judge Kaczynski made this as a First Amendment argument. I know of no other circumstance in which the fact that your statements could be employed as evidence in a legal suit that's not against you as an individual, right? And the travel ban suit names Trump, but it's not against Trump in his personal capacity. It's against Trump in his official capacity, right? The fact that your statements will be employed in a suit against somebody else, that doesn't count as the kind of penalty we usually think of as being as constituting or creating a chilling effect, right? The mere fact that you have said something and it could be used in public, and it could be used against you, right, is a consequence of the fact that you've said something. It's not a consequence of necessarily of the law per se. And so I have a hard time seeing why there is a legally cognizable chilling effect. I'm also not sure why a judge would think that excluding campaign speech from litigation would aid the democratic process as opposed to undermine it. Surely, if we take elections seriously, we would think that the statements that candidates make in the run-up to elections we're supposed to take them as being credible. I know that's we live in Illinois, yes, it's difficult. We're supposed to take the statements that candidates make as being credible predictions of what they're going to do. And if everyone, including judges, treat them as being credible, that makes the process of democratic contestation more robust and it gives it more integrity. So the idea that you would not take statements seriously because of their effect, because doing so would somehow undermine the democratic process, it seems to me to have things exactly backward, right? The way you take democracy seriously is by assuming that the people engaged in democratic contestation are doing so in all seriousness and with all due respect to the voters. Is that kind of responsive?
Statutory rationale that reportedly the president will be using to exclude nationals based on the claim that their entry into the country would somehow be harmful to the interests of the United States. Is there some teaching in the framework of the INA that would suggest to what degree that finding has to be evinced in some form of articulated rationale or demonstrated rationale, so as to indicate that it's not an arbitrary and capricious, expansive ruling?
Yes. So were we under the Administrative Procedures Act, there would be a way of doing that, and there would be a body of case law. You mentioned arbitrary and capricious review under the Overton Park case that would enable that kind of review for basic rationality. The president, however, does not fall under the APA. The president is not an agency as a consequence of an opinion from the early 1990s called Franklin versus Massachusetts. And the kind of review that is available for the president is non-statutory. Right? What does non-statutory mean? So everyone, I take it, read Marbury v. Madison in law school, right? Right? It's one of the few times that you get to cite Marbury because it's actually relevant precedent. So Marbury is about non-statutory review. Marbury is about the use of something called a common law mandamus action that was available then under Section 11 of the Judiciary Act, that's available now actually under something called the All Writs Act, to challenge an official act by James Madison, the Secretary of State. So the form or the vehicle for review is different, right? The vehicle for review here is it's called a non-statutory vehicle, and there's some back and forth about exactly which one we're under, whether we're under the All Writs Act, whether we're under, for those of you who have not completely blocked out Fed courts, I wouldn't blame you, the federal equivalent to Ex parte Young. Huge. I know people are like, I don't want to hear that. Too many bad memories. So there's a number of different theories of what the vehicle or the right of action is. And depending on which of those theories you accept, the ability to challenge discretion, the exercise of discretion goes up or down. So there are cases from the 1800s that suggest that under certain, and actually, well, there's some language in Marbury that has this flavor, that when an official is given a discretionary duty, when they have to exercise some measure of discretion, you can't challenge how they exercise that discretion. You can only challenge if they go beyond the frame of the statute, right? And there's a trace of that kind of committed to agency discretion idea actually in the APA too. So one thing that's important to know is that depending upon how you conceptualize the challenge, maybe you get to challenge the discretion, maybe you don't. I think that let's say that the court accepts that this is a form of challenge. This is a kind of challenge in which it can look at how the discretion has been exercised. There, I think that the plaintiff's best argument is that the statute says the president is allowed to prohibit entry when he finds that these aliens' entry would be detrimental. That's not the finding. That's not the finding in the statute. The finding in the statute is these countries don't have adequate security at their airports and in their passport issuance. Right? Those are two different things. The fact that a country doesn't have adequate passport control doesn't tell you anything about the group of people who come from that country. This is, I think, most forcefully the case with respect to Syria, which is one of the countries for which there is more or less a blanket prohibition, where somewhere between a quarter and a third of Syrians live outside Syria's borders because there's a civil war. They're not within the jurisdiction of the Syrian government. They're not walking around with passports that they've just gone and gotten from the Syrian embassy. They're for all intents and purposes, stateless persons, right? So the notion that you would ever look to the Syrian government for confirmation of who these stateless persons in Jordan or in Lebanon are is far-fetched, right? So the Syrian example, to my mind, most crisply illustrates the mismatch between the set of findings that are actually in the order and the finding that is required by the statute, right? But to get there, to get to that argument, you have to go through this thing about this long, tortured, convoluted thing about what kind of action it is and whether we're an ex parte Young land or whether this is a mandamus. And I can already see people glazing over it like, oh. Was that responsive? Okay.
Why is Hawaii a claim?
It's good politics. So can you be more precise? Because you could be asking about like why did the governor decide? Uh-huh. So there are family members and of people who are denied entry, in addition to the state, who are plaintiffs in the Hawaii case. Why does Hawaii have standing is an issue that the government has raised and is before the court. I think it is reasonably likely that the court will resist the idea that Hawaii has standing. So I think the question is very fair. So just focusing upon I will take your question as being about the law, not about the politics.
Yeah,
is that fair? Yeah, so states have standing in a number of different, slightly different conditions or circumstances. One of those conditions is if the states are engaged in some function and that function is impaired or becomes more costly because of something the federal government has done. So the argument of Hawaii, and this was the argument of Washington State in the first iteration of the travel ban, is we run universities, we require the entry of people into the country in order to man these universities, and it turns out that the travel ban prohibits people who we would have come and play roles in our universities and our institutions, but who are prohibited from entry as a consequence of the ban, and that prohibition has a material effect on our ability to carry out missions that the state engages in, such as the provision of education. I think this was a stronger argument. So two things. The first thing is that this is not a trivial argument. I know from working with the University Council's office at the University of Chicago that particularly in the sciences and particularly with respect to Iranians, this has been a big problem, right? There are people who we would bring in for in particular in the medical school to do basic research and who are not able to get in because of the ban. There's a very well publicized case of a leading artificial intelligence researcher who's Iranian, who has University of Toronto has hired him, right? Because he can't enter the US. So it's a non-trivial argument. The argument that it's one, the claim that it's one that Hawaii can make, though, is a little difficult, right? And this is going to sound horribly snobby, but Hawaii would have to point to, I think, some element of the state university system that is impeded by the operation of the third travel ban. And that's much harder, in part as a consequence of the exclusion of students of Iranian extraction. Because I think it's the Iranian students who are the ones for whom the best argument was. That's always been the argument from the U of C. Right, so it was always Iranians, and it was generally students. Turns out that the student exceptions don't cover everybody, particularly postdoc researchers, and so our university still has problems. But it's not wholly clear that Hawaii is going to be able to make that showing. Hawaii has another argument which I don't find as compelling. And it's called the parens patriae argument. It's the idea that the state can stand in the shoes of its citizens and protect the interests of its citizens. The court has run hot and cold over time over the idea of states having parens patriae standing. Although query why any state has the authority, or why more pointedly, why does the United States have authority to bring a criminal prosecution under Article 3 standing doctrine, right? The U.S. isn't harmed, right? The U.S. is the plaintiff in a criminal case. There has to be standing for that case to go forward. Why does the U.S. have standing? The analogy would be to that, right? I think the point that I just made about the U.S. and criminal cases is one of those nice law professor points that nobody in the real world cares about. So I don't think that the parens patriae standing will get very far. And this argument from economic effects, I think, is, it's not a terrible argument, but it's not a slam dunk either. But even if you ding Hawaii as the plaintiff, there's other plaintiffs in the case, and I can imagine justices being like, look, we really don't care. We're not going to. Hawaii's not the only plaintiff. We ding Hawaii if we want this case to go away. If we ding Hawaii, the case doesn't go away. I'm not going to waste my time doing standing or state standing. I'm gonna focus on you have no right of action. Right. That's probably going to be then you get rid of the whole case. Right. Is that responsive?
Following up on that question.
Yeah.
I don't recall the exact specifics, but Texas and a bunch of states sued the Obama administration over the DAPA
Yeah.
program.
Yeah.
I recall that a bunch of me and my progressive legal friends were
that progressives are hypocrites. Sure, law professors are perfectly aware that we have our preferences and that we flip them around, and there were all these professors who were outraged by United States versus Texas, and now we're all gung-ho about Hawaii versus Trump. Yeah, no, but the charge goes the other way too, right? Because the conservatives are all gung-ho about US v Texas, and now they're up in arms about Hawaii v Trump. So the accusation cuts both ways. The standing argument in US v Texas was basically the one that I just described. It was the idea that Texas would end up spending more money on things like giving out driver's licenses if federal immigration law was not enforced to the hilt as a consequence of DAPA, right? Which is it's just another financial effect story, right? And remember that Texas versus United States ends with a 4-4 Supreme Court split. So there were at least 4 justices who thought that was a colorable theory of Article 3 standing for a state. And I'm betting those 4 justices were not called Justices Breyer, Ginsburg, Sotomayor, and Kagan, right? So, take from that what you will.
Crystal ball. So where does this go?
So notwithstanding the fact that I'm writing an amicus, I think that the plaintiffs will lose. I think it's sort of up in the air whether they'll lose on justiciability grounds. I think a part of me wants the. I think that the most likely ruling is either a narrow ruling on justiciability or a statement that, something that says, the president has this authority under the statute, the discretion looks wide, and we're just not going to dicker with it, right? Something like that. I think it's very unlikely that the court gets to the constitutional issues. I think if the plaintiffs win, they win on a very narrow statutory ground. They win on this kind of Brown and Williamson, King v. Burwell argument that I made. It's not just my argument. It's an argument that's out there. But I think that's like a less likely outcome than a more likely outcome. But that's mostly just by looking at who the justices are and thinking about how they vote. So, great.
Okay.
I just have one more question.
Yeah.
The statutory argument.
Yeah.
And the argument about where the 65 Act
Uh-huh.
quote is based on nationality.
Yeah. Yeah.
Eradicated,
Yeah.
and their approach to interpret the rest of the INA as not allowing.
Well, no. There was quotas were eliminated by the Hart-Celler Act in '65, and then a couple of years later, Congress added an additional provision to the INA prohibiting nationality discrimination with respect to visa issuance. And the government says, that's about issuing visas. It's not about entry. Right, so therefore we can discriminate with respect to entry even if we can't discriminate with respect to denying visas. And the response to that is, look, entry and visas are entwined, right? People get a visa and they enter, right? They're functionally 2 parts of the same thing. So it makes no sense to say everyone is entitled to. You can't discriminate on the basis of visa applications or visa issuance, but you can discriminate when the person turns up with a valid visa at the border. That's kind of crazy. So the statutory argument is about a specific non-discrimination by nationality provision. Did I answer the question, or?
Yeah, that actually was my question.
Okay.
I have one more question. Actually, I have a lot of questions, so it was hard for me to decide. So with respect to the latest decision in Jennings versus Rodriguez,
Mhm.
that decision was based on the statute.
Yeah.
And that's why I agree. I think due to the fact that they're arguing
Yeah.
a statutory argument, that's
Yeah.
why it might fail. So I think I'm still confused as to why you think a statutory argument is still stronger than a constitutional argument, since the court decided the way they decided in Jennings versus Rodriguez. If that was a constitutional argument, would that have?
I think so Jennings v. Rodriguez is a case about the availability of bail for people who are detained on immigration grounds. And the court reads the immigration statute to say there's no entitlement to bail, and we're not going to read the statute to create one, because that would be reading it improperly. As the dissent, I think, in that case rightly points out, the earlier cases, excuse me, can I just... I know I'm going out of the image. I'm sure that they can't even watch this. Will be okay for a second. By ruling the way that it did, the court in Jennings indicated that it didn't think much of the constitutional argument. It is much easier to win a statutory argument on constitutional avoidance grounds than it is to win a full-blown constitutional argument. That's just my view and my judgment based upon the time that I've spent in litigation and what I've seen in practice. It is much easier to win a statutory case than a constitutional case. It is much, much easier to win a statutory case than to win a constitutional case that requires the Supreme Court to say the president is a bigot. They're just not going to do that. The court is just not going to do that. That's it. I don't say that as a matter of, doctrine or law, but just as a matter of blunt political realism. This court is not going to turn around and call the president, regardless of what he has said, a bigot. It's not the way that this court behaves. It's not the way Supreme Courts generally have behaved. And if you can't do that, you have lost the constitutional argument, and all you are left with is the statutory argument. I don't think that Jennings proves anything with respect to the wisdom of statutory versus constitutional arguments, because I don't think that if Jennings had brought a constitutional and a statutory argument, they would have necessarily won the constitutional argument. Rather, I think what Jennings tells us is that 5 justices on the court don't think much of the constitutional argument. So I don't draw the same lesson from Jennings that you're drawing. Cool. Well, thank you very much. I really appreciate it. No, thanks.